facts alleged against the Attorney General of Alberta. 2. In the alleged breach of the Charter Section 15, S.J. Bykewich, acting dishonestly and in bad faith, for a fraudulent purpose, maliciously destroyed the relevant inculpatory evidence relating to the CPSA, L.R. Alhauser, and C.D. Boyer, and the exculpatory evidence relating to A.J. Arkey, with the potential evidentiary value, referred to as the Exhibits S1, Respondent Copy, 33 of the Provincial Court of Alberta File Number 161129408P1, in contravention of the Criminal Code of Canada Section 139, Obstructing Justice, and Section 341, Fraudulent Concealment 34 the LSA Code of Conduct Rule 5.1-9, C, Handling Evidence 35 and Rule 5.1-10, Incriminating Physical Evidence 36 and participated in the destruction of that incriminating and exonerating evidence in order to obstruct the course of justice in the Provincial Court of Alberta File Number 161129408P1 and the Court of Queen's Bench of Alberta File Number 1703. 18,804, thus failing in her legal duty as a member of the LSA to disclose the relevant information. And in contempt for the Alberta Rules of Court Rule 3.18, Notice to Obtain Record of Proceedings 37 failed to comply with the September 21, 2017 Notice to Obtain Record of Proceedings 38 for the April 4, 2018 Court of Queen's Bench of Alberta Court Schedule, was properly complained about to the LSA by the appellant on 2018.06.0639 and on 2019.03.25, 40 S.J. Bykewich lied to the LSA in her LSA complaint reply about never before seeing the Exhibits S1, Respondent Copy, that were intended for the examination by the Provincial Court of Alberta and the Special Prosecutions of the Alberta Justice and Solicitor General 41 despite her November 21, 2016 and August 23, 2017 letters to the contrary, and with respect to the rules of the LSA Rule 87.2, Review by Independent Counsel 42 and Rule 87.3, Investigation, 43 should have been investigated by the LSA Independent Counsel to determine whether that failure was an ethical violation. Attorney General of Alberta. 81 The respondents are the L.R. Alhauser sympathizers with no concern for the harm that he had caused to others. Similar to the mental health professionals in Cohen, L.R. Alhauser deceived the court, the RC, the respondents, and the Lieutenant Governor of Alberta, with his father figure facade. The Attorney General of Alberta, Alberta Minister of Justice and Solicitor General, appointed L.R. Alhauser to be the LSA Public Representative. 185 The agent of the Attorney General of Alberta ordered the stay of proceedings against the CPSA and L.R. Alhauser in any event, destroyed the inculpatory and exculpatory evidence, and lied about never seeing that evidence when those materials were used to determine whether or not to order the stay of proceedings. 186 Our jurisprudence has provided the standard to determine whether S.J. Bykewich improperly destroyed the Exhibits S1, Respondent Copy, and thus the spoliation of evidence. In Indian v. Canadian Red Cross Society, 1998, at paragraphs 26 to 27, that stated 187. 82 S.J. Bykewich knew of the pending or probable litigation involving the appellant, the CPSA, and L.R. Alhauser, and that the litigation that existed was probable. As a result of the willful destruction of Exhibits S1, Respondent Copy, that was designed to disrupt the Provincial Court of Alberta File Number 161129408P1 and the Court of Queen's Bench of Alberta File Number 1703 to 18804, and thus caused the irreparable prejudice to the case of the appellant that manifested in the biased and illegitimate LSA complaint and appeal dismissals, S.J. Bykewich must suffer all the inconvenience that is the result of that spoliation of evidence, and the Court of 29. Appeal of Alberta should make an assessment of all of the damages that have been pleaded. With respect to the proceedings against the Crown Act Section 5, liability of Crown in tort 188, the Attorney General of Alberta must be held liable for that breach of the Charter Section 15 by its agent, S.J. Bykewich, against the appellant. S.J. Bykewich must be held professionally liable for her contravention of the LSA Code of Conduct Section 5.1-9, c, and Section 5.1 to 10, and with respect to Alberta Rules of Court, Rule 10.52, 3, a, I, Declaration of Civil Contempt 189 be declared in contempt of court, for the contempt not in the face of the court, for her non-compliance to the Alberta Rules of Court Rule 3.18, notice to obtain record of proceedings, for not complying with the September 21, 2017 notice to obtain record of proceedings, and for the spoliation of evidence, and be held criminally liable for her contravention of the Criminal Code of Canada Section 139 and Section 341. In R.V. Wajees Ha, 1995, at page 4, that stated 189. 83 in Specific Estate v. Imperial Tobacco Ltd., 1998, at pages 8 to 10, that stated 190. The Court of Appeal of Alberta is the superior court of criminal jurisdiction that could enforce the Alberta Rules of Court Rule 10.53, Punishment for Civil Contempt 191 and the Criminal Code of Canada Section 139 and Section 341 indictments and summons against S.J. Bykewich. 84 in the March 25, 2019 LSA Appeal Reply, S.J. Bykewich stated 192. Some guidance with respect to the reasonableness of a document retention policy, and whether that is a valid justification for the inability to produce the documents, could be provided from the American jurisprudence in Louis v. Remington Arms Co., Incorporated, 1998. That stated 193. 85 in Nels v. Ontario, 1989, at page 171, that stated 194. 86 The agents of the Attorney General of Alberta receive no absolute immunity for the damage that they have caused, a tort that they have committed, or a breach of duty attaching to the occupation, possession, control, or concealment of property. S.J. Bykewich has acted contrary to the Victim of Crime Act Section 2, Principles 195 and maliciously in fraud of her duties with the result that she caused the damage to the appellant. The illegitimate stay of proceedings, the spoliation of evidence, and the unjustified delays by the Attorney General of Alberta, have resulted in the appellant suffering from the health complications due to the stress-induced hyperthyroidism 196 forced to study the Canadian law, and being unable to concentrate on his education or on his employment, nor function as a normal member of our society. 30. 87 in 1998, the malicious actions of L.R. Althauser traumatized the appellant and caused him to drop out of the enrollment at the University of Alberta, and to never return. The malicious actions by S.J. Bykewich exacerbated the suffering of the appellant, and the prejudice towards him, and perpetuated the contempt towards A.J.R. Key that resulted from the libel published by L.R. Althauser. Given the totality of the circumstances, and that the Honorable Associate Chief Justice J.D. Rook did not examine the facts nor the evidence in the application dismissals, the $3,000 tariff imposed on the appellant, $1,000 to each of the three respondents 197A is illogical. If S.J. Bykewich would not have destroyed the evidence, that sensitive and complex case would have been transferred to the special prosecutions to be prosecuted in the Provincial Court of Alberta. Between 2015.08.06197B and the present, at the minimum wage employment in Alberta calculated at $15 per hour and 8 hours per day. Earning the $120, at 5 days per week earning the $600, at 4 weeks per month earning the $2,400, at 12 months per year earning the $28,800, at 5 years, the appellant could have earned the $144,000. Therefore, with respect to the proceedings against the Crown Act Section 4, right to sue Crown 197C, and Section 16, rights of parties 197D without including the aggravated damages, the minimum compensatory damages caused by the Attorney General of Alberta to the appellant are calculated to be $144,000. See indictment. With respect to the Criminal Code of Canada Section 788, 2. 1 Justice may act before the trial, and Form 2, Information, the appellant seeks the summons from the Court of Appeal of Alberta for the indictment of the CPSA and L.R. Allhauser for Section 22.1, Section 22.2, Section 122, Section 139, Section 180, Section 219, Section 299, and Section 465, 1b, for Section 465, 1b, by C.D. Boyer, and for Section 139 and Section 341 by S.J. Bykewich. D. Declaration. A. The appellant seeks the declaration from the court that the respondents abused the civil practice note number 7, paragraph 6. B. The appellant seeks the declaration from the court that the LSA and the Attorney General of Alberta breached his Charter Section 15 equality rights, and that the CPSA breached the Charter Section 15 equality rights of AJRK. C. With respect to the Crown Liability and Proceedings Act, Section 22, Declaration of Rights 216 and the Alberta Rules of Court, Rule 34. 10.52, 3, a, I, Declaration of Civil Contempt, the appellant seeks the declaration from the court that S.J. Bykewich is in contempt of court. F. Expedited trial, due to the 5 years of the improper delay and the obstruction of justice that resulted thereof, the appellant requests the expedited trial in the Provincial Court of Alberta or the Superior Court of Criminal Jurisdiction. E. Damages, the appellant seeks the Charter Section 24 compensatory and punitive damages for the harm caused by the respondents. A. The compensatory damages include I $144,000,